Sir, I rise to speak on the Securities and Insurance Laws Amendment and Validation Bill 2010. I thank you very much for giving me this opportunity to make my maiden speech as well as to lead the debate from the opposition on this very important subject. I have heard the Honorable Finance Minister, a very senior parliamentarian and minister who presented certain facts about the ordinance and now the bill and the thought process that went behind it. Sir, I shall come to those issues a little later. At the outset, I would like to speak more about the big picture that the bill has raised. There is two major issues that this ordinance and subsequently the bill has raised in terms of the big picture. First is the joint regulation of the hybrid products. Obviously, the bill relates to the hybrid products, and whenever there is a dispute between two regulators in the regulation of hybrid products, the second issue is the joint mechanism which has been proposed in this bill, which I believe compromises the independence and autonomy of the regulators. I shall explain my thoughts a little more in detail. First, the issue about the joint regulation of products. It is not something which is new in the realm of possibility in the Indian financial markets. We have had joint regulation of products in operation for several years in this country already. There are time tested practices in vogue, and few disputes have arisen over the years. Regulators are not new in this country. We have had regulators for over 20 years and a multitude of regulators, but we have not had such type of disputes as has been witnessed between SEBI and IRDA come to the public fora, public domain very often. This is one such case, and sir, I beg to submit that this case also could have been handled better, could have been managed better, and there was no reason to have a knee jerk reaction of the ordinance or a big bill into parliament just at the occasion of one instance. Usually, these disputes have been sorted out and handled at a lower level very efficiently. If they were not handled by bipartisan discussion, they were taken to the high level committee for coordination in the financial markets and very amicably resolved over the years. Joint regulation is also not new in the markets. Joint regulation has been happening for currency derivatives for several years now. Both SEBI and RBI have been jointly regulating currency derivatives. In fact, very recently, the Select Committee on Financial Sector Reforms has proposed the establishment of a Financial Stability and Development Council, which could be a quasi judicial body headed by a judge or a legal luminary or a domain expert. Even the Planning Commission has said that it would solve most of the issues relating to regulatory competition. I believe the government should have introduced this type of a mechanism rather than a joint committee headed by the finance minister in which the power of decision are taken away by the political and the executive body of the government. I think the dispute resolution mechanism would have been better served by such a type of body rather than going in for a bill which has decided at the government level who will regulate in the case of ULIPs and has also decided on taking over so many powers of the regulators. What should be done in respect of hybrid products? Who should regulate? How should ULIPs be treated? Sir, international practices vastly differ in respect of ULIP type products. In UK, they do not have the separate regulators. The Financial Services Authority of UK has a department which regulates all the products. There is a single regulator. But occasions arise where a particular branch may be the security board, may be the insurance authority, differs with the FSA. In such cases, the FSA first tries to resolve the dispute internationally. It does not go to any outside authority. Like in India, it tries to resolve it internally. If unresolved, the mechanism there is an independent complaints committee. It is not a super regulator. It is not a committee which the government is involved in. It is not a committee headed by bureaucrats and ministers. It is an independent complaints commission which takes these matters, addresses them, and if there is still a problem, at the end of the day, you go to the courts of the land. The laws provide to go to the courts. Sir, there is another difference in the international practice, and I draw the attention of the Honorable Finance Minister to this very important aspect of how ULIPs are regulated in different companies. Sir, ULIPs certainly come under the regulation of the insurance regulator, but there is an important difference. All investments under the investment portfolio of ULIPs are outsourced to asset management committees which are under the regulation of their respective securities exchange board. But there are two segments of it. One is the insurance part. As regards the investment component, to avoid duplicity of regulator, the investments are only operated by outsourcing the investment activity to a duly registered asset management committees which works under the guidelines and regulations of their securities exchange board. In this case, the investment companies do not do the investment functions themselves directly, and that is the fundamental difference which we in India should address. Insurance should have got to maintain its control on the insurance business. Investment would have been done through bodies which have domain knowledge, who are controlled and regulated by the securities board, and there would be no overlapping and confusion. In fact, sir, there would have been a major saving of costs instead of duplicating the entire effort and the whole organization to do investment. Insurance companies could have outsourced the two people with domain knowledge, and they would have been properly regulated by the securities board. I can quote a number of international companies which follow the practice.